Hello friends, in the series on the income tax cases, today we will discuss the case of SAP Labs India Private Limited versus Income Tax Officer. This case has been reported in 454 ITR at page number 121. The matter has been decided by Supreme Court and the date of the judgment is 19th April 2023. In this case, a batch of special leave petitions were before the Supreme Court on the issue that whether the determination of the arm's length price involves the substantial question of law and whether the High Court should hear those matters or those appeals where the tribunal has not determined the arm's length price according to the chapter 10 of the Income Tax Act, which involves section 92, 92A to 92 CA, 92D, 92E, 92F and rules 10A to 10E of the Income Tax Rules 1962. Earlier, various high courts have rejected the appeal of the assessees and at the same time, in some cases, rejected the appeal of the Income Tax Department on the ground that Income Tax Tribunal is the last fact-finding body and the determination of the arm's length price is a question of fact and it does not involve the substantial question of law. So they declined to hear those appeals which were regarding the determination of the arm's length price. So this matter was before the Supreme Court. The Supreme Court said that the complete code has been given in the Income Tax Act in chapter 10, where section 92, 92A to 92 CA, 92D, 92E, 92F and rules 10A to 10E of the Income Tax Rule 1962 are there. If it is clear that the tribunal has determined the arm's length price, dehors these provisions, then it will be said that the determination of the arm's length price is perverse and it involves the substantial question of law. Or in other words, it cannot be said that where the tribunal has determined the arm's length price or has given its verdict about the arm's length price, then it cannot be assumed that it is correct and the High Court cannot hear that matter. So in conclusion, it can be said that in determining the arm's length price, the ITAT can misapply the provisions of chapter 10 and rules. So in every case, a blanket rule cannot be there that the ITAT is the last fact-finding body and the High Court cannot decline to hear those appeals. So in this case, a number of appeals have been brought together and the Supreme Court held that and remanded back all those matters where the arm's length price computation was done by the ITAT or the last fact-finding body, and it was concluded that and it was directed to the High Courts to hear those appeals where the provisions of chapter 10 and rule 10A to 10E has not been applied properly, or in other words, it can be said that it was directed to the High Court that you have to verify whether those provisions have been applied correctly or not. Friends, this is a very far-reaching effect judgment because determination of arm's length price is a very complex procedure and it will cast a very heavy burden on the High Courts for those appeals regarding the arm's length price. Because in this case, we have seen that there are some comparables which the assessee says that these are comparable entities but the department does not consider them and a vice versa. So it will involve a good time of the High Courts to determine those appeals. At the end of this video, once again, I am repeating the name of the case. The name of the case is SAP Labs India Private Limited versus income tax officer, and this case has been reported in 454 ITR at page number 121. The matter has been decided by Supreme Court and the date of the judgment is 19th April 2023.